Okay, so Miss Dugas is on probation for the offense of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Miss Dugas. Has everyone had an opportunity to review that? Are there any additions or corrections?
Okay, pause. Did you catch that? The defense had 0 corrections. Translation: they know this case is a hot mess and there's not much they can argue. What would you do if you were her lawyer right now? Let me know in the comments.
All right, and this was unagreed, correct? Ms. Holmes, you may proceed.
Thank you, Honor. I've spoken with Ms. Dugas. Obviously, the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses, not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
All right, let's break down this moment. She's asking for yet another shot after multiple violations. But probation isn't a get-out-of-jail-free card. It's more like 1 strike and you're on thin ice. And she's got like 5 strikes. What do you think? Too harsh or fair?
Miss Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just robbed someone else, you failed to ID, failed to report to probation, you committed the new offense of possession of a controlled substance, you resisted arrest, it's ridiculous to me that you're saying you want a second chance, because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Miss Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that you're stop crying, because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity. Right? Miss Malfino?
Whoa, the judge is not holding back. And honestly, can you blame her? Crying now doesn't undo the robbery, the drugs, or skipping probation check-ins. This is courtroom reality TV at its peak. What's your take? Tough love or overkill?
Report to probation. You committed the new offense of possession of a controlled substance. You resisted arrest it's ridiculous to me that you're saying you want a second chance, because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Miss Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years, in my opinion, is not enough. You had every opportunity to do all the things that you're stop crying, because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity. Right?
Quick legal sidebar. In Texas, habitual offender status is no joke. If you mess up after 2 convictions, that third one could land you behind bars for 25 years minimum. It's basically the legal system's version of "we warned you twice."
Voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of robbery. Going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. I hope you take some advantage of this and actually do what you're saying you're going to do when you get out and change your life. There's programs in prison, take advantage of them, but you're not going to continue to get opportunities like this. If you continue to violate the law after this, you're going to be considered a habitual offender. And if you do anything again, your minimum punishment is going to be 25 years. 25 years minimum for what you've been doing. So you need to change your life or you're never going to see your kids, right?
Both cases show us something bigger. Probation only works if you do. The judge is practically begging them to change their lives, but they keep self-sabotaging. Question for you all. Do you think probation sets people up for success, or does it set them up to fail?
Are you Wesley Antoine? And Mr. Antoine is here for sentencing on probation, a deferred probation for aggravated assault, family violence, and that was a 10-year deferred probation that he was given back November 14th of 2023. Entered pleas of true, it looks like, to counts 1 through 11 in the motion to revoke unadjudicated probation. I've received an updated pre-sentence report. This was an open plea to the court, is that correct?
Yes, Your Honor. The court had previously, when we were here before, it advised the court, that he received 4 months on that new case in Louisiana, but it does involve the same victim, Miss Red, as his case here.
Mm-hmm.
We had discussed 6. The court did not feel comfortable with that, so we've just decided to go on to you.
Okay. All right. So that's what, and I wanted to remind myself, I had a notation on this about that new offense. So the new offense was in Louisiana, and it was domestic abuse, battery, also by strangulation, correct? Against the same victim. All right. Mr. Lewis, you may proceed.
Judge, in this situation, of all my conversations with Mr. Antoine here, a lot of his issues come back to his mental health problems. And at the time, I believe he was not really open about getting the help that he needed with these issues. And once he got on probation, of course, those issues took over where he became in a very unstable situation. He admitted that he was homeless for a period of time there, which why he went back to Louisiana. All his family is there. We had some sort of support system.
And here's what I love. This judge is equal parts strict and fair. She acknowledges life struggles but refuses to let them become excuses. Would you rule the same way in her position? Drop your verdict in the comments.